Hi everyone. So this session that we're doing, the unit we're doing is Principles of Criminal Law. My name is Shazia Khan, and we'll be doing Learning Outcome 4 today, which is the last learning outcome, which is to understand the general defences to criminal conduct. Before I go through Learning Outcome 4, I just want to give you a little bit of an idea of what we did in the last learning outcome, which was a recap of Learning Outcome 3. So in Learning Outcome 3, we looked at elements of criminal damage and criminal liability under the Criminal Damage Act. We looked at what aggravated damage is. We also looked at the element of theft with appropriation and property belonging to another. We looked at dishonesty, intention to deprive. We also looked at definitions of criminal damage and aggravated criminal damage and theft. We looked at key elements such as destruction or damage. We looked at endangered to life and also mens rea. And we looked at the element of defences under Criminal Damage Act 1971. And we looked at defences such as appropriation, dishonesty, and elements of property belonging to another. And we looked at reference to cases such as the Turner case, Oxford and Moss. We looked at the Velleman case and the IFA principles, which were adopted in the IFA test in 2017. We also looked at the element of mens rea, guilty mind without lawful excuse. We looked at application of actus and mens. We looked at analysis of actus and mens rea for elements of theft. And we then also looked at the intention to permanently deprive, section 6, application of actus and mens rea, and we also looked at the element of defences of criminal damage in more detail. Okay, so that was the element of a quick brief outcome of what we did in a summary of what we did in Learning Outcome 3. Now we're moving on to Learning Outcome 4, which is the final learning outcome. And also we'll be looking at understanding the general defences to criminal law. The indicative content for Learning Outcome 4 is to look at intoxication, voluntary and involuntary intoxication, classification of offences, so specific intent or basic intent, voluntary intoxication, duress, Piper and DPP cases, threats of death or serious injury, mistake as to fact, not law, self-defence and strict liability. So key terminology, general defences include things like intoxication, mistake, insanity, duress, and self-defense, which we'll be going through in more detail. The next element of that is a video that we've put on here that you can look at in your own time, and this looks at the criminal defences available within the criminal law and what they are. So it goes in detail. So have a look at that in your own time. So understanding general offences to criminal conduct. General defences in criminal law are legal strategies that can reduce liability or establish innocence. They include things like self-defence, insanity, duress, necessity, and automatism. And these defences are categorised in justification where the act is deemed acceptable under the circumstances and where there's mitigation as well. So general defences, self-defence is a defendant can use reasonable force to defend themselves or others from an attack. So that's a form of self-defense as well. And also the legal basis is under Section 3 of the Criminal Law Act 1967. The key elements is necessity of force, where the defendant must genuinely believe the force was necessary, proportionality of force, where the force must be reasonable and proportionate to the threat. And the famous cases are on Gladstone-Williams, 1987, where a defendant's honest belief in the necessity of force was sufficient, even if mistaken. And the case of R. and Martin, 2002, excessive force used by a farmer to protect his property was deemed unreasonable. The element of duress. So we'll look at duress in regards to criminal law and why that is so important and why it's a defense in criminal law. So duress occurs when a person is forced to compel or compelled to commit a criminal act because of a threat or imminent harm or serious injury from another person or a situation. Essentially, the accused did not act of their own free will and was under a threat of violence or serious harm if the act was not carried out. So, it's a common law defense which is used quite widely now, and people take advantage of people when they do, identify areas of duress. So elements of duress, key elements are things like immediacy of threat, proportionality, and exclusion for certain crimes. So the elements is that the accused was coerced into committing the crime, and the pressure was applied was illegitimate or unlawful, and the accused was threatened with serious injury or violence if they did not commit the crime. So, there could be examples of that is when someone is forced to commit a crime due to the threats from another, when someone is forced to enter into contract due to illegitimate pressure. So there's different elements of that you could consider. The next one is insanity as well, and what that is within criminal law. So the insanity defense is a legal concept that allows a defendant to be excused from criminal liability if at the time of the crime they were unable to understand the nature of their actions due to severe mental disorder. The legal concept is utilized during trials to assess whether an individual should be held criminally responsible for their actions if they were unable to comprehend those actions were illegal. In legal contexts, the insanity defense can prevent a conviction or result in a reduced sentence. The criteria for this defense can vary between jurisdictions, but the central principle remains that a significantly impaired mental state leads to an inability to understand one's action. Generally, the insanity defense hinges on principles set out by various psychological assessments and the rules regarding mental competency in criminal law. So the legal basis for this is trying to understand the elements of insanity, and there's popular cases such as the case of Aaron Sullivan, which looked at the M'Naghten rules, which the M'Naghten rules focuses on whether the defendant understood the nature of their acts or could distinguish right from wrong while committing the crime. It's an element, and it's quite, it's quite hard for some elements people to understand this, but cases are there to identify elements of insanity and how it could be used as a defense. So another case is a case of Aaron Windle, 1952, where the statement, "I suppose they'll hang me for this," showed awareness of wrongfulness, negating insanity. The next one is automatism. Automatism is a rare legal defense that can be used in criminal cases when a defendant lacked the capacity to control their actions. It can be caused by external factors like intoxication or internal factors like mental illness. Types of autism: you have insane autism caused by mental illness or disease, which results in the verdict or not guilty by reason of insanity, or sane or non-insane autism caused by an external factor which results in a verdict of non-guilty. So the involuntary act or the external factors results are made. The cases are Bratty and AG for Northern Ireland and Aaron Quick, 1973. The next defense is intoxication. And intoxication is a state of mind, or a state of reduced mental or physical control caused by drugs or alcohol. In criminal law, it can affect a defendant's ability to form the mens rea or the intent to commit a crime. So you've got voluntary intoxication and involuntary intoxication. Voluntary intoxication can prevent proof of criminal liability if the crime was committed with a specific intent. And involuntary intoxication can negate the mens rea and may be a defense if the defendant's intoxication was through no fault of their own. And cases in regards to that is the case of DPP and Majorski, 1977, where voluntary intoxication is not a defense for basic intent crimes. and the case of R and Kingston, 1994. Involuntary intoxication is not a defence if the defendant still had the required mens rea. Mistake. In criminal law, a mistake of fact could sometimes be a defence, but a mistake of law usually is not a defence. And the case in regards to that is the case of Aaron Smith, 1974. The defendant believed the property they damaged was their own, negating the mens rea for criminal damages. The summary table looks at the defences, which self-defence, duress, insanity, automism, intoxication and mistake, and looks at the type and the key elements and key cases for that in the table. So in conclusion, general defences like self-defence, duress, insanity, or automatism, intoxication and mistake serve to mitigate or eliminate liability in criminal cases. These defences address situations where the defendant's actions, though unlawful, must be justified, excused, or lacking the necessary intent. By considering the defences, the legal system balances justice with fairness. 4.1 Definitions of intoxication, duress, and strict liability. So the first one is intoxication. So intoxication refers to a legal defence strategy in criminal law where defendant argues that they were incapable of forming the necessary mental state or intent required to be found guilty of a crime due to being under the influence of alcohol or drugs at the time of the offence. However, the intoxication defence can potentially affect the outcome of a trial by showing that the defendant lacked the intent required to commit a particular crime. The viability of this defence often depends on whether the intoxication was voluntary or involuntary. And we'll look at that in a little bit more detail so you've got a little bit of an idea. So voluntary intoxication occurs when an individual consciously chooses to consume drugs or alcohol. In many jurisdictions, this type of intoxication is not typically a valid defence for serious crimes. In contrast, involuntary intoxication arises where a person is incapacitated by substances without their consent, such as through being drugged or consuming a substance unknowingly. And the cases are the case of DPP and Magistrix and R and Gallagher. So involuntary intoxication is when someone commits a crime while under the influence of drugs, as we mentioned, without their knowledge or consent. It can be a complete defence to a crime if the defendant lacked the intent to commit it. For example, if someone's drink is spiked with alcohol, or someone has administered drugs while unconscious, or someone unknowingly drinks a beverage laced with a drug that causes incapacitation. The defence is available if the defendant can prove that they lack the intent to commit the crime, and the defence is not available if the defendant had intent to commit the crime, even if they were involuntarily intoxicated. And the popular case in regards to that is the case of R and Kingston, 1994, where a defendant sexually assaulted a boy under the influence of a spiked drinks. The court held that the involuntary intoxication is not a defence if the defendant still possesses the intent to commit the crime. The next one is the classification of offences specific and intent. So specific intent offences are crimes that require proof of intention or special mental states. This means that the offender must have intended to commit the crime. Examples of specific intent offences are murder, burglary, arson, armed robbery, GBH, and forgery. The intention or knowledge of wrongdoing is part of the crime. For example, to prove a Section 18 GBH charge, the prosecution must show that the offender intended to cause serious injuries when they assaulted the victim. And then you've got basic intents, requires recklessness more than intent, and voluntary intoxication does not negate recklessness. duress. So duress defense is a legal defense that can be used when someone is forced to commit crime. It's available for all crimes except murder, attempted murder, and treason. The defendant must have been forced to commit the crime under duress. The defendant must have not been at fault for getting involved in the situation, and the defendant must have had a reasonable belief that they were in danger, or the defendant must have had a good cause to fear for their safety. When the defendant's actions cause more harm than the threat they faced, and when duress is not applicable, is in that instance. Cases are the case of R and Hassan 2005, where duress is not available if the defendant voluntarily associates with people likely to expose them to threats, and R and Ho 1987, duress is not a defense for murder. Strict liability. Strict liability offences are crimes that do not require the prosecution to prove the defendant's intent, knowledge, or negligence. In these cases, the defendant can be held liable even if they try to avoid the harm. The key features here is no mens rea required. The defendant's mental state is not relevant, so no mens rea. The purpose is used to protect public's health, safety, and welfare. And the defences are, it's limited. Defences are available even honest mistakes may not be absolve liability. The injured party in strict liability defences does not need to prove negligence or fault to receive the damage. And a really important case in regards to that is the case of Sweet and Parsley, where the court ruled that strict liability offences should not be assumed unless explicitly stated by the statute. So in summary table at the end, intoxication, voluntary intoxication, involuntary intoxication, duress, strict liability. So in this table, it looked at the definition of each of them aspects and key cases and the application. So you can have a look at the end of it in regards to that. So conclusion, intoxication, duress, and strict liability highlight diverse legal approaches to criminal liability. While intoxication and duress consider the defendant's state of mind and circumstances, strict liability imposes liability based purely on the actus rea, emphasising the protection of public interest, and the nuanced application of this principle ensure fairness in the legal system. 4.2 circumstances in which intoxication can provide a defence. So intoxication can only provide a defence in criminal cases when the defendant was so intoxicated that they were unable to form the necessary specific intent required for the crime they are charged with, meaning they lack the mental state to commit the crime intentionally. This is typically only applicable to crimes requiring a high level of mental intent, not general intent crimes. So types of intoxication and applicability. So types of attention and voluntary intoxication, as we mentioned before, is when someone knowingly consumes an intoxicated substance with specific intent. Offences, DPP and magistics, and basic intent, voluntary intoxication is not a defence. Limitations, a drunken intention is still an intention, and the case example is R and Gallagher, 1963, where a defendant who drank alcohol to gain courage to commit murder was still found guilty because he had preformed intent. Involuntary intoxication, as we mentioned before, involuntary intoxication is where the defendant becomes intoxicated through no fault or knowledge of their own. Here it will be a complete defence, so as long as it is proved that the defendant lacked the mens rea to commit the offence. And the case of R and Kingston, where the defendant's drink was spiked, but because he retained the intent to commit the offence, the defence of involuntary intoxication failed in this case. Classification of offences and intoxication. In criminal law, when considering intoxication as a defence, offences are typically classified into specific intent and basic intent, which I mentioned earlier on as well, where voluntary intoxication can only be used as a defence against specific intent crimes, as it may not negate the requirement mens rea. for a basic intent crime, meaning if someone is intoxicated and commits a basic intent crime, they are still likely to be found guilty because the recklessness of getting intoxicated can be considered through enough to establish the necessary mental state for the crime. So you've got basic intent and you've got the specific intent. So specific intent, these require high level of mental intent, meaning the accused must have intended to cause a specific result beyond just the act itself. Examples include attempted murder, where the prosecution must prove the accused attempted to kill someone. In such cases, voluntary intoxication can be used as a defense if it is prevented the accused from forming the necessary specific intent. Basic intent offences, these require a lower level of mental state where recklessness or no knowledge of potential consequences is enough to establish guilt. Examples include assault, where the prosecution only needs to prove the accused intended to apply force, not necessarily to cause serious harm. Voluntary intoxication is generally not a defence for basic intent crimes, as the act of getting intoxicated itself can be considered reckless. The exceptions and practical considerations is the first one, the Dutch courage. In criminal law, Dutch courage is when a person uses alcohol or drugs to commit a crime. The law states that someone is still liable for the crime, even if they were intoxicated at the time. The law assumes that someone who intends to commit a crime while sober and then gets drunk to carry it out still intended to commit the crime. For example, if someone plans to kill their spouse and then gets drunk to carry it out, they cannot use intoxication as a defense. Intoxication can be a factor in other legal principles or defenses. For example, if someone is spiked with alcohol at a party, the resulting drunkenness might be involuntary and could be considered as a possible defense. And then mistaken belief due to intoxication. So if intoxication leads to a mistaken belief, the defense may not apply, especially in crimes of basic intent. So the summary table identifies the cases in regards to types of intoxication, offences and the outcome. So DPP and Majestics, Aaron Gallagher and Aaron Kingston and Aaron Lipman in regards to voluntary and involuntary types of intoxication. So intoxication provides a defense under limited circumstances. Voluntary intoxication may negate mens rea for specific intent offences, but not for basic intent of offences. Involuntary intoxication can provide a defense to both types of offences if it negates mens rea, but is not available if intent is still formed. The next one is 4.3, circumstances in which duress can provide a defence. It is important to note that the defence of duress only applies as long as the threat of immediate and serious violence is present. Once the threat is removed, there can be no further justification for actions. For example, driving under the influence in drink driving cases. Types of duress. You have types of duress, which two types: physical duress, which is involves threats of force or violence, and duress by threats, duress by circumstances as well, which is another one. The defendant acts unlawfully because of external circumstances, and these are the elements of two types of it. So key elements of duress, that the key elements of duress are threat, lack of consent, and no reasonable alternatives. So immediacy of the threat. So the threat must be immediate and constant, as in the case of Aaron Abdul Hussein 1999, where hijacking was justified under duress as the threat of death was imminent, even though not immediate in time. The seriousness of the threat must be serious, such as death or serious personal injury. The case of Aaron Valderrama Vega, threats of death combined with other pressures can amount to duress if the threat of death is significant, and proportionality of the offence, so that the crimes committed must be proportionate to the threat faced. Other key elements are things like there's no safe avenue of escape. So they're forced to do it. and that's the case of R and Gill, 1963, where the defendants failed because the defendant had an opportunity to escape but did not take it. Voluntary association, where the defence is not available if the defendant voluntarily associated with individuals or groups likely to expose them to threats or coercion, example R and Hassan, and threat directed at the defendant or others as well. Crimes excluded from duress. As we said, duress is no defence to murder, attempted murder, or seemingly treason involving the death of the sovereign. In general, courts do not accept a defence of duress when harm done by the defendant is greater than the court's perception of harm threatened. This is the test of proportionality. As in the case of R and Hort, the defence was rejected for a defendant who participated in a murder under threat. The next one is defence duress by circumstances. And duress of circumstances is a legal defence that applies when someone is forced to act due to circumstances other than threats. It can be used in cases where someone is forced to commit a criminal act. Example, driving offences committed to escape immediate threats. And a popular case in regards to that is the defendant drove recklessly to escape individuals he believed were about to attack him, and the court allowed the defence in the case of R and Conway, 1989. Another case is the case of R and Willer, 1986, where the defendant was charged with reckless driving. He claimed he was forced to drive in a dangerous way because he was being chased by a gang. The case summary table in regards to that, it looks at the element of the cases. So it's looked at the defendant genuinely believed that the threat was real and imminent. Conditions to succeed duress, and the belief was reasonable and would compel an ordinary person of similar characteristics to act in that way. And the defendant had no reasonable means of avoiding threat or escaping. The law limits the nature of threat that has been placed on the person for them to qualify as being under duress. The threat must be one of death or serious personal injury, either to the defendant or his immediate family or someone close to him. So it can't just be anything, people cannot just claim the defence of duress. They have to meet certain requirements, and because then everyone would be saying it's duress. So there are exceptions in place that are, that won't fall within this. In conclusion, duress provides a limited defence to criminal liability when a defendant acts under coercion to prevent greater harm. Defence is unavailable for murder and other serious offences, which I've said because, it can't just apply to everything. Courts need to evaluate the actions and look at everything proportionally so that they are acting reasonably and making sure that they are not making a wrong decision. Duress cases involving threats of death, serious injury, is the case of there are cases that commit crime in regards to it, and courts will look at that. And there are some cases like the case of Hassan, 2005, RE 2000, Dudley and Stevens, Pommel, Piper. There's a case example of R and Singh, R and Hassan, which we've just mentioned. So there are some case examples, and they are available on Moodle for you as well, the additional ones. Key principles of duress. So key principles of duress include the existence of a threat, the nature of the threat being illegitimate or improper. The pressure applied must be significant enough to overcome a reasonable person's will, a lack of reasonable alternatives for the victim, and a casual link between the threat and the action taken under duress. Essentially, a party must be coerced into an agreement through a legitimate threat, leaving them no viable choice but to comply. So illegitimate pressure, so the threat must be considered illegitimate or improper under the law, not just a tough bargaining tactic. Nature of the threat must be serious enough to cause a reasonable person to face significant harm, such as physical or substantial economic loss. The victim must have had no reasonable option other than to succumb to the pressure. Causation as well. So the threat must be direct cause of the victim's action, meaning they were compelled to act due to duress. And while the threat must be objective, serious, the court may also consider the victim's individual state of mind and their perception to the threat as well. And now exclusions, as we said, it's not available for murder. Key case is the case of Aaron Hassan 2005, which I mentioned earlier, voluntary association with criminals. The facts of this case is that the defendant associated with criminals was coerced in committing a burglary under threats of violence. The ruling in the House of Lords held that duress is not available if the defendant voluntarily associates with people likely to expose them to coercion or threats. And the principle that was adopted from the Hassan case was that defendants cannot claim duress if they knowingly place themselves in a situation where coercion is foreseeable. Another popular case is the case of Re 2000, necessity as a defence. In this case, the legal principle of necessity was applied as a defence allowing for surgical separation of conjoined twins, even though it would result in the death of one twin, as it was considered the lesser of two evils to save the life of the stronger twin, justifying the action as medically necessary to prevent greater harm, essentially establishing that necessity can be a defence in extreme situations like this, even though it involves a taking of a life. The legal issue that was identified, the court had to decide if the operation to separate the twins, which would lead to Mary's death, was legally permissible. The court ruled that the operation was lawful under the doctrine of necessity, meaning that in this extreme situation, the act of killing one twin to save another was justified because it was the only way to prevent a greater evil. And the necessity defence in Re A is considered a very narrow exception and is unlikely to be applied in other situations where someone takes a life. So it's quite a hard decision to make. The case of Aaron Dudley. In the 1884 case Aaron Dudley and Stevens, the court ruled that necessity is not a defence for murder. The case established that even in dire circumstances, it is not unlawful to kill another person to save oneself. It was a crew of a yacht were cast adrift in the lifeboat after a storm. After nearly 3 weeks at sea, 2 of the crew killed and ate the ship's cabin boy to survive. The 2 men were charged with murder. The court emphasized the sanctity of human life. The court rejected the idea that necessity could be justification for killing, as it would create a dangerous precedent. The court held that moral dilemmas do not justify breaking the law. The defendants were found guilty of murder and sentenced to death, but were released shortly after. Aaron Pommel, 1995. So in this case, the case of Aaron Pommel, Aaron Pommel, the element of the facts, defendant was found with an illegal firearm and claimed he was holding it to prevent harm to another person. The court allowed the defence of duress by circumstances as the defendant acted to avoid a greater harm. The principle that was adopted was duress by circumstances can apply if the defendant's action were necessary to prevent death or serious harm. The element of the next case is Piper and DPP, driving under duress, 2012. This is a legal case where the defendant, Mr. Pipe, argued that he was driving under duress of circumstances, essentially necessity, when he exceeded the speed limit while rushing his son with a broken leg to the hospital, meaning he was forced to break the law due to an emergency situation, and the court ultimately upheld his conviction despite the mitigated circumstances of urgent need to get medical attention. Mr. Pipe was driving his son to the hospital after the boy sustained a broken leg during a football match. Pipe argued that he was driving under duress of circumstances, meaning he had no choice but to exceed the speed limit to get his sons to medical care quickly. The court found that While the situation was urgent, the speed at which Pipe was driving was excessive and not justified by the necessity to reach to the hospital. Even when facing a genuine emergency, the defence of necessity may not be successful if the application actions taken are deemed disproportionate to the threat. When claiming duress of circumstance, the defendant must demonstrate that they acted in a way a reasonable person would in similar circumstances. So the summary table in regards to the application threats of death or serious injury, it looked at the case of R and Hassan, Re A, Re Dudley and Re Pommel and Pipe, as we did, and looked at the facts of the case, the ruling and the principles that were established from the case. So it gives you a summary of what we've done in discussing the cases. In conclusion, the defence of duress is available when threats of death or serious injury compel the defendant to commit a crime, provided the response is reasonable and proportionate. However, it is not applicable for murder, attempted murder, or in cases where the defendant voluntarily exposes themselves to coercion. The outlined cases illustrate the nuanced application of duress and its limitations in criminal law. Mistake. 4.4, mistake as a defence in criminal law. In criminal law, there are two main types of mistake: mistake of fact and mistake of law. A mistake is as to criminal law, or ignorance of it is no defence to a criminal charge. However, a mistaken belief that an act is not criminal may afford mitigation. In many situations, a criminal defendant may wish to argue that he or she never intended to commit a crime and the criminal act that occurred was a result of a mistake of facts regarding the circumstances of the crime or misunderstanding concerning the law at the time. Such mistakes of fact can be applied to a variety of criminal activities, but mistakes of law are only rarely allowed as full defence to criminal conduct. So the first one we're going to go through is mistake of fact. Mistakes of fact arise when a criminal defendant misunderstood some fact that negates an element of the crime. For instance, if an individual is charged with larceny but believed that the property he took was rightfully his misunderstanding negates any intent to deprive another of the property. One important qualification, however, is that this mistake of fact must be honest and reasonable. Thus, a defendant cannot later claim that he or she was mistaken when he or she actually knew the situation. Likewise, the mistake must be one that would appear reasonable to a judge or jury. If the same individual was repeatedly told the property was not his and he could not take it, it would no longer be reasonable for him to mistakenly have believed that he could rightfully take the property. Mistake of fact may apply to a variety of crimes. Some crimes may set forth that mistake of fact is a defence. Otherwise, if criminal defendant can prove that the mistake reasonably negated an element of crime, the defence will usually be held to apply and absolve the defendant of liability. And the popular cases are the case of Aaron Smith, 1974, and DPP and Morgan. In Aaron Smith, the defendant damaged property believing it was his own, and the mistake negated the mens rea for criminal damage. And the DPP and Morgan, 1976, defendants who believed that they had consent for sexual activity were entitled to argue their honest belief. Mistake of law is a defence that the criminal defendant misunderstood or was ignorant of the law as it existed. At the time, the onus is generally placed on individuals to be aware of the laws of their state or community, and thus this defence only applies in very limited circumstances. For example, while a defendant will not be able to claim that he was not aware that murder was a crime, he may be able to argue that he was not aware of some obscure traffic law. Specifically, mistake of law can be used as a defence in four limited circumstances. Firstly, when the law has not been published. Secondly, when the defendant relied upon a law or statute that was later overturned or deemed unconstitutional. Thirdly, when the defendant relied upon a judicial decision that was later overruled. Or fourthly, when the defendant relied upon an interpretation by an applicable official. Additionally, the defendant's reliance on any of these sources must have been reasonable, much like mistake of fact. Thus, a defendant cannot claim that he was relying on a case from 200 years ago when it is apparent that there have been subsequent developments in the law. And the case of Aaron Aesop, 1836, a defendant who committed an act legal in his home country but illegal in England, was still held liable as ignorance of English law was not a defence. Mistakes and types of offences. So you've got mistakes, you've got special intent offences. Mistakes can negate from special intent required to commit the offence. And the case of Aaron Smith, which is honest belief that the property belonged to the defendant, negated intent. You've got basic intent offences. Mistakes must be both honest and reasonable to negate any sort of recklessness. A case of DPP and Morgan. And strict liability offences where mistakes are rarely defence for strict liability claims as mens rea is not required. An example of that is selling restricted goods to minors. Key cases in regards to that, which we'll go through, is Aaron Smith, 1974, where the facts: the defendant damaged wiring in a rented property, believing it belonged to him. The ruling is the court ruled that a genuine belief that the property was his negated the mens rea for criminal damage, and the principle was an honest mistake of fact can provide a defence if it negates intent. DPP and Morgan, 1976, a man invited others to have sex with his wife, claiming she consented. The others honestly believed in her consent. The ruling was an honest belief in consent, even if unreasonable, could negate the mens rea for rape under the law of time. And the principle adopted here was an honest mistake about a fact central to the offence can negate mens rea. The final case is Aaron Tolson, 1889, where a woman remarried believing her first husband had died. The court ruled that her honest and reasonable mistake negated criminal liability for bigamy, and the principle, a reasonable mistake of fact, can provide a defence in specific circumstances. So in conclusion, the summary table identifies mistake of fact and mistake of law with reference to the definition, applicability, specific intent crimes, basic intent crimes, strict liability, and looks at key cases as well in regards to that. In conclusion, mistakes, particularly of fact, can provide a defence in criminal law if they negate the mens rea required for the offence. While mistakes of law are generally not a defence, mistakes of fact are most relevant in crimes requiring specific intent. Courts assess whether the mistake was honest to determine whether liability should be reduced or eliminated. 4.5, analysis of defence of self, others, or property. So the defence of self, others, or property is a legal defence that allows individuals to use reasonable force to protect themselves, other people, or their property from imminent unlawful harm, but only when the force is used proportionate to the threat faced, meaning it should not exceed what is necessary to defend against the danger. Key aspects include the concept of imminent threat, reasonable force, and proportionality. Self-defense in criminal cases. So at common law, the defence of self-defence operates in three spheres. It allows a person to use reasonable force in defending himself from an attack, preventing an attack on another person, or defending his property. So the key elements of self-defence: necessity of force, reasonable force, and case examples there as well. So we'll go through the first one, which is the defense reasonable force. So the general principle is that the law allows only reasonable force to be used in the circumstances, and what is reasonable is to be judged in light of the circumstances as the accused believed them to be. In assessing whether the defendant had used only reasonable force, Lord Morris, in the case of Palmer and R, felt that a jury should be directed to look at particular facts and circumstances of the case. Another case in regards to reasonable force is the case of R and Owino, 1995. And in regards to the imminence of the as we stated, the amount of force must be reasonable in the circumstances the defendant believe them to be. The force must be proportionate to the threat, and the defendant may have some allowance for acting in the heat of the moment. So, it is an element of, how someone would try to protect their property in regards to self-defense, and it is governed by common law principles to protecting oneself or others. The cases are R and Gladstone Williams, 1987, where defendant intervened to protect someone he believed was being assaulted. The court held that an honest belief, even if mistaken, can justify self-defense. And the case for reasonable force was the case of R and Clegg, 1995, where a soldier who used excessive force was denied the defense of self-defense as his actions were disproportionate to the threat. Proportionality in self-defense cases is the case of R and Martin, 2002, where a farmer who used a shotgun against intruders was found to have used this disproportionate force, and protection of others in the case of R and Rose, 1884, where a person acted to prevent harm to their family was allowed to claim self-defense. So there are statutory bases in Section 3 of the Criminal Law Act 1967, which needs to be taken into account when looking at self-defense. Defense of property, and the case example here is to put someone to protect their property. A defendant used a firearm to protect their home from unlawful eviction, which was deemed self-defense in the case of Aaron Hussey, 1924. Limitations of self-defense is the defense does not apply if the force is used as retaliation or vengeance after the threat has passed. An example, seeking revenge for a past attack, and the case example, excessive force, is R and Clegg. Strict liability in criminal cases. So in regards to strict liability, offences of strict liability require proof that the defendant performed the prohibited conduct, but do not require proof that the defendant was blameworthy. And in regards to that, the most strict liability offences are minor offences. The criminal law covers a wide range of crimes from murder at one end to parking tickets at the other. At the lower, and such offences are often regarded by general public as not really criminal. These less serious offences play the role of regulating people's behaviour so that society can work effectively rather than indicating the defendant has behaved in a morally reprehensible way. Strict liability offences should be distinguished from negligence-based offences where the prosecution must demonstrate defendant acted unreasonable. The vast majority of strict liability offences are found in statutes, although there may be a few common law strict liability offences. And the mens rea and the actus reus as well, case examples of strict liability. First case is the case of Sweet and Parsley, 1970, where a teacher unknowingly rented her property to students who grew cannabis. The court ruled that strict liability must be explicitly stated by the law. And the next case is the London Borough of Harrow and Shah, 1999, where a shopkeeper was held liable for selling a lottery ticket to a minor, even without intent or negligence. So comparison between self-defense and strict liability is the element of strict liability and absolute liability are both legal concepts that hold a party responsible for damages without requiring proof of fault or negligence. The main difference between the two is that absolute liability applies to all uses of something, while strict liability usually applies to specific situations. Such as inherently dangerous activities or defective products. The defendant is responsible under strict liability for damages caused by their possession or something dangerous, even if they were careful. Examples include things like what we said, the lottery ticket, but it could include things like selling alcohol to minors and statutory rape. And this comparison table identifies the legal basis of self-defence under Section 3 of the Criminal Law Act and strict liability regulated statutes. Mens rea requires intent to protect oneself, others, or property. For strict liability, does not require proof of intent or knowledge. For the aspect of proportionality, for self-defence, actions must be proportionate to the threat forced, and the strict liability, relevant liability arises from the act alone. The application for self-defence is crimes involving force, and strict liability applies to public welfare offences, and key cases are on Gladstone 1987 and Sweet and Paisley 1970. So the summary table identifies the case law with reference to principles that were established in these cases and the outcome that was established in that case as well. In conclusion, the defence of self-defence, including protecting others or property, provides legal justification when the use of force is necessary, reasonable, and proportionate to the threat. In contrast, strict liability offences impose liability without regard to intent or self-defence, focusing instead on protecting public welfare. Courts carefully evaluate whether the force used in self-defence aligns with legal principles, ensuring fairness in its application. So now that we've finished Learning Outcome 4, these are the references used for Learning Outcome 4. I'm just going to give you a recap of what we've done in Learning Outcome 4 today. So you've got a little bit of an idea. So we looked at understanding the general defences to criminal law. We looked at intoxication, involuntary and voluntary intoxication, classification of offences. We looked at the element of general defences to criminal conduct, such as self-defence. We looked at case law on duress and insanity. We looked at automatism, intoxication with reference to cases. We also looked at mistake under criminal law, and we also looked at definitions of intoxication, duress, and strict liability. We went on to further look at involuntary intoxication and classification of offences such as specific intent and basic intent. We looked at duress, strict liability. We looked at case law. We looked at elements of circumstances in which intoxication can provide a defence. We looked at classification of offences, exceptions and practical considerations. We looked at the element of Dutch courage, and also looked at circumstances in which duress can provide a defence, duress by threats, duress by circumstances. We also looked at, in duress, crimes excluded from duress, murder and attempted murder. We looked at cases involving threats of death or serious injury, and we looked at popular cases such as RE-RA, Aaron Dudley and Stevens, Aaron Pommel and Pipe and DPP. We also looked at mistake as a defence in criminal law. We looked at types of mistake of fact and mistake of law with reference to cases. We also looked at the element of analysis of defence of self, others, or property. We looked at self-defence in criminal law and the key elements of self-defence with reference to case law. We then looked at proportionality, protection of others, and prevention of crime. We looked at strict liability in criminal law and looked at case examples such as Sweet and Paisley and London Borough, Porrow and Shah. We also looked at elements of the cases that applied in regards to self-defence and strict liability, and we looked at the difference between each of them. So now we've finished Learning Outcome 4. We finished all the learning outcomes, and the next session we will have is assignment discussion session. So we've done Learning Outcome 1, 2, 3, and 4. The next session is assignment discussion session. All these sessions will be recorded and put on Moodle for you to have a look at and to listen to when it comes to doing your assignment. These resources were used for Learning Outcome 4, so you could go onto these links, and some ebooks are available on Moodle. Again, refer to ebooks and journals on Moodle to help you. I've put a link there for a PDF document. It's a revision notes, but it'll help you in regards to general defences in criminal law. Looks at insanity, it looks at self-defence, ministry responsibility. It's quite a nice document to have a read of, and it's a PDF document that you can download and read in regards to it. Any queries or any questions you have, please email learnerwork@ukvarsity.co.uk. The submission of the assignment is on learnerwork@ukvarsity.co.uk, and its submission is 2 weeks after the completion of the unit. So now the completion of the unit is done, we've just got the last session to do, which is the assignment discussion session, and then you will have 2 weeks to do the assignment. Thank you for attending the session. Any questions, please email learnerwork@ukvarsity.co.uk. Thank you.